Hi, everyone. Welcome to this webinar. I think I've probably met virtually a number of you at the last webinar. So thanks for coming back and welcome to those of you who are new. My name is Donna Marshall and I'm a specialist in workplace harassment. I've been working in this field for over 20 years as a clinician, as an educator, and as an expert advisor to organizations across Canada and the United States. So let's begin. So what's going on out there? We've had Jian Ghomeshi, Bill Cosby, Harvey Weinstein, Kevin Spacey, Judge Roy Moore, and it goes on and on. Daily, if not more often than daily, we are getting people coming forward saying that they've been harassed in their workplace. And these cases are not actually new, as you know. They're just new to our awareness. Many of these cases go back many decades, but I think people are just starting to speak out now because, first of all, there are some laws, and Canada is great in implementing laws to protect workers, as well as people are having the courage because we've got a lot of people coming forward now, and there's a momentum being gained that is not going to stop. But it's not just happening out there. It's going on in our own workplaces as well. And as recent as October 2017, last month, Abacus Data released a survey, and I'd recommend that you look this up. Just look up abacusdata.ca sexual harassment, and it'll come up for you. Couple of statistics: over half of adult women in Canada, representing 8 million women, have experienced unwanted sexual pressure at work. It goes on to say that more than 1 in 10 Canadians, both men and women, say sexual harassment of women in the workplace is actually quite common. And we know, too, that it's not just women who are harassed in the workplace. Anyone can be harassed and sexually harassed in the workplace. So I also want to differentiate between sexual harassment and harassment in general. And I'll talk about that in a minute, but I do want to bring another statistic up, which is 50% of Canadians report being harassed at work at least once in the last 6 months. So these are actually horrifying statistics. I think we would all agree with that. So I want to do a quick review for you. Some of you know this already, but I do want to bring us all together around this. The Occupational Health and Safety Act has a two-part definition of harassment. And this definition that I've got up on the screen now was what we consider Bill 168. And harassment was defined as engaging in a course, which means a pattern, a vexatious, which is unpleasant, which is a very broad term in itself, comment or conduct against a worker in a workplace that is known or ought reasonably to be known to be unwelcome. So that's our definition of harassment, and you can see that it's very, very broad and quite subjective. And then what we know now is Bill 132. It doesn't take away Bill 168. It adds on to the definition of harassment in 168. So Bill 132 adds the following. Harassment, definition of harassment, engaging in a course of vexatious comment or conduct against a worker in a workplace because of sex, sexual orientation, gender identity, or gender expression, where the course of comment or conduct is known or ought reasonably to be known to be unwelcome. And this next piece is very important for not-for-profits. Making a sexual solicitation or advance where the person making the solicitation or advance is in a position to confer, grant, or deny a benefit or advancement to the worker, which means this is a person in a senior role that would have the power to either hire, fire, or make someone's professional life very, very unpleasant. So all leaders really need to be aware of this, and I would also mention board members also need to be made aware of this extra emphasis on leadership and their obligations. And the person knows or ought reasonably to know that the solicitation or advance is unwelcome. So what I'd like you to remember as not-for-profits is that the experience of harassment can be subjective. I mean, we can look at some and say that's obviously harassment, but there are so many gray areas in this legislation that we have to be very cautious. And I would like you to focus on behavior with this legislation, behavior and actions. Is it a behavior? Is it something verbal that's said? People can interpret things different ways. So something that may not be offensive to me might be very offensive to some of you in the audience and vice versa. So it is often subjective and in the eyes of the beholder. The intention of the person doing the behavior really doesn't matter. So when someone says, and if you're doing an investigation and they say, well, I didn't really mean to offend them, that actually doesn't matter. The focus needs to be on the impact of the behavior on the other person or person. So let's look at some acts of harassment so that we're coming together again around some behaviors. So companies need to be mindful that employees can now claim damages for the impact of repetitive behaviors that take a toll on a person's psychological well-being. And I'm going to actually talk about some cases that one came across my desk just this morning before this webinar. So repetitive behaviors are very important, and they break people down psychologically. So some examples of this might be extreme micromanaging. I had an example where I was called into a company because a woman reported that her manager was micromanaging her. And when the woman didn't do what her boss wanted her to do, the boss actually moved her desk beside hers and watched what she was doing every minute of every day. So that's obviously extreme. Micromanaging can make people feel insecure and not good at what they do, and that starts to wear down their confidence over time. Intrusive invasions of personal space, leaving someone out of crucial meetings necessary for job success. I was working with a woman who was a senior VP at a large institution, and she had a new boss who came in this case it was a man, but it doesn't really matter, who wanted his friend in her role. And so he just kept leaving her out of meetings. He kept not giving her information. He would humiliate her in meetings as if she didn't know things, which she didn't because he kept her from that information. And eventually, of course, she took legal action against them because they made it impossible for her to do her job. That's harassment. Excessive, unmanageable work overload. I'm aware of a person who was so competent that his boss continued to add so many additional responsibilities to his job in the most outrageous way that he could no longer cope. And this was a very strong man who was extremely competent in his job, and he was being set up to fail because of the unmanageable workload. Stealing others' intellectual property or their innovations or their ideas and representing it as their own. This is not uncommon, unfortunately, and it's a form of bullying and harassment. Shunning people, scapegoating people, blocking someone's path, not by mistake, but if they're standing in front of a door and not letting someone out, that can be conceived as harassment and setting someone up to be unsuccessful. Acts of sexual harassment. So what we need to keep in mind here as employers is that the more serious the violation, the more serious the damages that can be brought against the organization, because the impact is greater and on the individual or individuals. So I'm just going to list a few very quickly. I think we know what these might be. Communications of a sexual nature, verbal, written, or electronic. Inappropriate or unwanted touching. Just assume that touching is unwanted, I would say. And then again, in not-for-profit, I worked in not-for-profit for quite a few years myself, and we have a lot of clients who are not-for-profit, and we're kind of huggy, caring people, and so, but not everybody is. So we have to be really cautious and careful because, again, sexual harassment is in the eyes of the beholder. So we may think it's okay, but it's not okay for that person. Touching another person's hair, clothes, or body, standing too close or brushing up against another person, any kind of seductive behavior, giving sexy gifts, neck massage. I actually was doing consulting with a large not-for-profit where the new director of one department brought back from an overseas trip a beautiful gift for one of the employees in his team, and then brought it over to her house to give to her. So needless to say, this was extremely concerning and extremely upsetting for the young woman. Referring to someone as hot or a hunk or a girl, a babe, those kinds of things. Personal inquiries about someone's sex life or sexual orientation. Just keep communication to the workplace and to the job at hand. Turning work discussions into sexual topics, relentless requests for dates or sex, ranking a person's beauty or desirability, she's a 10, he's a 5, things like that. Offering professional incentives for a date or sexual contact. So that's just a few of the things that we can think of in this area. And I also want us to know that when it comes to the organization protecting its workers, its employees, harassment and sexual harassment can come from anywhere. So you might get it when you look at the very center of this circle. You'll see a client could harass an employee. A client could harass a volunteer. A customer can harass an employee. A volunteer can harass a leader. A board member can harass an employee or a leader. So this can go from anyone to anyone. And for this reason, we recommend, although it's not in the legislation, we recommend that volunteers and board members learn the Bill 132 requirements and receive other anti-harassment training. So caution must always be the order of the day when we're acting and interacting and communicating with anyone in the workplace. So as we all know, things are rapidly changing out there and within our own organizations. So I want to very briefly touch on some of the latest, which is happening extremely rapidly. The first thing is that there are new federal regulations coming out in 2018. Now, at this point in Ontario, we've got Bill 132. We've also got the Human Rights Code. Of course, there's the Human Rights Code in federal regulations, but it is not as strong as it is in provincial. Now this is being bumped up. So with the federal regulations coming into force within the year, they're aimed at giving workers and their employers a very clear course of action to better deal with allegations of bullying, harassment, and sexual harassment. And this is going to exert much more pressure on companies to combat unacceptable behavior. And the terminology, if you read the literature, is punish those who don't take it seriously. So even the language around these issues now is becoming very serious. The rules, once they come into force, will apply to all federally regulated workplaces. And I don't know if any of you listening to this are federally regulated or not. Some examples would be banks, telecommunications, transport industries. I'd actually be interested to hear if any of you are federally regulated, just for my information. The next big piece of information, and I just got something on my desk today, is around chronic mental injury, which again is also coming into effect January 2018. So this is referred to as Bill 127, which was passed in May of this year, and it allows for compensation for work-related chronic mental stress. So the article that I read, which came from a law firm, says, according to this policy, any worker who can show that they have a diagnosed mental stress injury caused by, quote, substantial work-related stressor, which includes bullying and harassment, is entitled to benefits. So this is changing the landscape already. The Workers' Safety Insurance Board, the WSIB, states that work-related chronic mental stress can be the result of harassment and bullying. So this is quite a big step as well. There's some parameters around how that's diagnosed, but this is significant. Then we've got changes to Bill 130, to the OHSA through through Bill 132 and the tort of harassment. So I'm going to be moving into those now. Today, we're going to be looking at the link between workplace harassment, the claims for mental injury, which I just mentioned, and the tort of harassment. We're looking at new employer risks due to improperly managed and investigated incidents of harassment. And this is also very serious. How you conduct your investigation or who you get to do that investigation is as crucial as doing the investigation. I'm going to give you a checklist of requirements for developing a harassment response program and conducting a proper workplace harassment investigation. And then we'll end with understanding how you can build a workplace culture of respect and accountability that can mitigate against there being harassment in your workplace. The article that I was reading from moments ago about the mental stress injury, this legal firm says employers need to take preventative measures to make sure these claims do not arise in the first place. And so I'm going to be talking to you also about what you can do, because it's always preferable to not have the incidents occur. So first, harassment and mental injury. I quoted this in the article that Charity Village ran as well, but I think it's quite a powerful and amazing quote, and that is that harassment is violence against the soul. Physical violence can be testified to by outside evidence, eyewitnesses, police, medical reports. With emotional abuse, there is no proof. It's a clean violence. No one sees anything. And this is by a psychiatrist specializing in psychological injury from harassment and abuse. In addition to advising organizations, I'm also a clinician with Dr. Stephanie Bott, an associate psychological therapy practice. And weekly, if not daily, we treat individuals whose lives have been completely decimated by the effects of workplace bullying and harassment. I met with 3 people yesterday whose lives are have been horrendously impacted on every single level because of workplace harassment. Some are literally unable to function, their relationships suffer, their children suffer, they can't work, they have financial problems because of that, and where before they were high-functioning individuals, and I would say most of the people that I meet with are very high-functioning individuals, and they've been worn down by the harassment in the workplace. They didn't have pre-existing mental health issues. So one of the greatest sources, and I think this is important for you to know too, we've got a big emphasis these days on mental health in the workplace, which is very, very amazing and wonderful. The problem or the link that we sometimes don't get is that harassment and bullying are the biggest cause of mental health issues in the workplace. So if we can manage these situations around harassment and bullying and put prevention programs in place, then our mental health claims are going to go way down, our short term, our long term. It's quite a cycle, actually. So it all goes together. So quoting Dr. Stephanie Bott, and a specialist in trauma related to harassment in the workplace, she says a psychologically healthy workplace is one where people go to work feeling safe, supported, acknowledged, and valued, where feedback is given with care, and where people are treated with integrity, dignity, and respect. And BizLife's tagline is, no one should ever be afraid to go to work. And that's our mission, and we share that mission and vision with Charity Village. And I'm sure you do too, or you wouldn't be here today. So let's talk about this tort of harassment. On February 28th of this year, Superior Court Judge Honorable Mary E. Valley ruled that a worker can sue their employer for workplace harassment in Ontario. Now, what makes this unique is that under human rights, which is different than Occupational Health and Safety Act, there could be, someone could sue their employer for damages. But this was the first time that under the definition of harassment that I read earlier for you, that a worker was able to sue their employer for the impact of workplace harassment in Ontario. So this is a very powerful change. I thought it would be interesting for you to see what Justice Valley addressed when she came to her decision as to whether this employee had a valid case to sue for damages. Was the conduct of the defendant toward the plaintiff outrageous? So this would be, in this case, obviously the employer, toward the person who was victimized, outrageous. Did the defendant intend, did the employer or the person within the organization intend to cause emotional stress? Or did they have a reckless disregard for causing the plaintiff to suffer from emotional stress? Did the plaintiff suffer from severe or extreme emotional distress? And finally, was the outrageous conduct of the defendant the actual and proximate cause of the emotional distress? So I can tell you that based on the literally hundreds of cases of workplace harassment with which myself or Dr. Bod have been advisors or involved with in some way, most of the individuals who we've treated have been harassed by someone in their organization and have suffered mental injury that would meet the criterion of Justice Valley in this case. So we need to be very cautious, and I think this is something that you could even take away and say, okay, this is something to look at ourselves when we're doing an investigation. It can be part of what we kind of hold in place as we're going through our questioning. Employer risks. The next thing I want to talk about and emphasize is investigations. I was speaking at a legal conference about 3 weeks ago and talking about the psychological component of Bill 132. So Bill 132 is really the marriage of three disciplines. It's legislation and or law, it's health and safety, and it's psychology. And you have to be very careful how you conduct investigations, or it can be very costly to the employer. Bill 132 places stringent new requirements on employers regarding how they will investigate and manage incidents of harassment in their workplace. Failure to meet these requirements plays a significant role in how the employer's ability to, in the employer's ability to protect themselves from liability. So there was an article that just came out last week that the title is Canada, a costly lesson in how not to conduct a workplace harassment investigation. And the author says that there was a decision released, which is the Court of Appeal in October, where an employer received a costly lesson on ignoring claims of workplace harassment and conducting an inept harassment investigation. The individual within the organization who was conducting the investigation, the court found that individual's investigation to be, quote, utterly deficient. And they said not only did this individual mishandle the investigation, they also, quote, mangled the termination process. They fired a woman after they had harassed her and then she couldn't cope. So this was horrendous. And this woman was awarded $60,000 in moral damages, 10 months for reasonable notice, and $25,000 in human rights damages. So this is recent. This is October. This is very important that we also look at how we conduct our investigation. Bill 132 says that as an organization, you have to develop a written program identifying how an investigation will be conducted. And there's a lot of criteria involved in that, some of which I will outline in the checklist. This was a piece that was added after Bill 168 as part of 132. In 168, all you had to do was put a policy in place. Now it says there must be a policy and a program that delivers on that policy. You must ensure that all employees and leaders are trained to understand both their rights and their responsibilities around harassment and sexual harassment. And you need to train a safe alternative person or team of people in your organization to respond to incidents of harassment and to conduct an investigation using the identified protocols. Now, the reason that the legislation calls for an alternative person is because that in nearly 80% of all cases of workplace harassment, the person who harasses is senior to the individual who is harassed. So you can't say, well, report it to your manager. It's probably your manager who's doing the harassment, or another senior leader, or maybe a board member who's got a lot of power and influence. So you have to provide someone who is trained to conduct a proper investigation internally, or a team of people, which is what we recommend, so that people have a number of alternatives to go to, or bring in someone from the outside to conduct the investigation. There have to be safe people to report to. So the written program, and again, we're offering this in partnership with Charity Village. We have the written program. We developed it and it's been reviewed by a number of law firms. In fact, a number of law firms are using our program. We developed the program including all of the investigation procedures, and we call it the Harassment Education Advisory Response Team Program, which we thought was a really nice acronym for HEART, putting heart into investigations and heart into organization. We recognize that developing a program is very difficult for employers. It's not necessarily your area of expertise, especially if you're in a smaller organization where you don't have the budget or human resources available to develop these programs. Larger organizations, it's much more reachable. But for smaller organizations and mid-sized, it's not so much. You can't, it's costly to call lawyers and get all the information yourself. So we put this together with fillable forms and everything that you would need. And then secondly, having been vetted by a number of lawyers and law firms, we have developed the training that outlines what your employees need to know and what your leaders need to know. So what often happens in online training or training for this legislation is that there's just one training program. And the legislation is quite clear in differentiating that there are separate responsibilities for leadership in organizations. So we've actually developed that extra model for leaders so that they know their responsibilities and they know what to do should an investigation be required. And then train your safe alternative person or team, and we do that through our investigation team training, which I often conduct within organizations or live web. The other thing is that we offer advisory support to organizations because, again, especially smaller ones, because it's hard to know. There's so many layers to harassment, the psychology around it, and some of the issues around it. We've been doing this for 20 years, so we do offer advisory support to organizations as well. So let's look at a checklist for your harassment program. These are a few of the vital things. There's a lot more, but these are a few and some of the really crucial ones. So I'll start with what your employees need to know. So you have to develop a program and investigation protocols, and you have to let your employees know what all of these are so that if there is an incident or they want advice, they know exactly who to go to, and they know things such as what constitutes a complaint. I've had organizations ask me, well, it's just conflict between two people. So I don't know, is that harassment? The person saying it's harassment, is that harassment? So, we need to identify what constitutes a complaint and, who should the individual report to in the organization. It's crucial that you identify those in your harassment program. What is the process when they report? once they know who to go to, what's going to happen? It's a scary thing for somebody to come forward. So how will their confidentiality be maintained? And what are the limits of confidentiality? You'll have someone come to you and say, I want to report this, but I don't want it to go anywhere because I'm afraid something bad will happen to me, that I'll get fired or that I'll get maligned, or because it may be a senior person. And so we have to actually put in place protocols of how they will be kept safe from being maligned or in any way have backlash or repercussions against them for reporting. So you have to have those things in place in your program and in your investigation. And that's the part of being kept safe and psychologically safe, ensuring that there's no backlash when they do report. And then how will they be notified of the results of the complaint? I met with a woman probably 6 months ago who worked for a significantly large not-for-profit organization. And she reported that her boss had yelled and screamed and sworn at her and basically threatened that he would get rid of her, and it was because she wouldn't do something he asked her to do, which was illegal. And so he didn't like this, and he made her life horrendous, to which she was off for I think it was 2 years, trying to recover. But she went to the designated person in the organization, and she reported this. And they said, okay, we will talk to him. They went ahead and talked to him, and she didn't hear anything back. She didn't hear anything back. She went back to that individual and said, what's happened? I want to know, like, what happened with my complaint? And all they said to her was, well, we talked to him and he said he didn't do it and you're a difficult employee, so that's the end of it. We believe him. That is not sufficient. Your investigation has to be completely transparent to the individual, but obviously with some confidentiality parameters in place. So as an employer, you need to develop a safe reporting process. How will you protect workers from power or influence differentials? So you need to look at influence as well as power. We understand power. It's the more powerful people in the organization. Influential differentials are interesting because maybe you have the CEO's daughter working in an organization. She becomes extremely influential because of the virtue of her relationship with that individual, even though she doesn't have a high power position in the organization. So these are things you have to keep in mind. You'll need to create an intake, investigation, and follow-up procedures forms, develop the investigation procedures, ensure that all employees know who to report a complaint to, which I mentioned a second ago, identify your confidentiality protocols, and make every effort reasonable to protect employees from backlash of reporting. One thing that I recommend, is that when you are interviewing the individual who is being accused, that you give them parameters of how they will relate to the person who has accused them. For example, not being in the same room together, alone, things like that. And that if they violate that or contact this person outside of those parameters, that will be considered another act of harassment against that person. And that will be investigated as an additional incident of harassment. And you tell the person who's been reported the harassment that they are safe, and let us know if that person does approach you. So those are some of the things that you can add in to create psychological safety in the investigation process. So creating and building a culture of respect and accountability. The idea, of course, is that there is no harassment taking place. So I can tell you right now, there's probably not an organization out there that hasn't been exposed to harassment in some form. And I think, again, being not-for-profits, we have another layer to consider because we do good. That's what we do, and that's why most people work for not-for-profits. They want to make an impact. They want to make a difference. But then we can sometimes be almost too compassionate, where we allow certain behaviors to slide, or we make excuses for people. Well, really, he's just touchy-feely, and he doesn't really mean anything by it. He's just, he just really cares about people. Or, she just likes to do a really good job, and so, she micromanages people, but boy, she gets those fundraising dollars in, and she's got those, big donors on side, and, so if she's telling some of the young women to go and have dinner with this donor, and these young women feel uncomfortable, you know what? We need that donor's money. So if that's what that donor wants, then we'll go ahead and do that. And these are actual cases that I have dealt with. So we just can't have that anymore. We have to create a culture where there is accountability by everyone, from the entry-level person up to the board and out to the volunteers. And it's very challenging for not-for-profits, because the volunteers are giving their time, they're giving their money, and they can break boundaries and make demands that are extremely uncomfortable for people, and it puts you in a really difficult position. So that's why I recommend that you really give everybody training, board members, volunteers, and of course all of your staff. So ensure that all your employees, regardless of their level or role in the organization, are held accountable to respectful behavior. Now, how do you do that when the person at the top is the most disrespectful, or the person at the top is the bully? How do you do that and even conduct an investigation when the investigation is against a senior person, because they have the power? So you may be the individual who's in HR, for example, or in health and safety, or whatever role, and you're going to do the investigation. And you're being told or strongly influenced that the investigation has to come out in a certain way, and that's all there is to it. It's putting your job at risk, which means you're actually being harassed by that individual. But what do? That's the person in power and control. And that's where I would say you need to get an external investigator to come in and handle these situations. If at any point you feel your investigation would be compromised, then you should bring in an outside investigator. We do that kind of thing. Legal firms do that. Certain legal firms do that as well. We work cooperatively with a legal firm to conduct them, but we also do it in a very psychologically safe manner as well, that promotes the dignity of all individuals and understands the dynamics within the workplace. So, when we look at the legislation that's out there, all the changes that are happening, you have no choice at this point as an employer in Ontario but to conduct effective investigations, to prevent harassment from happening, to create psychologically and mentally healthy workplaces, because employees are being more and more empowered to come forward with the laws on their side, legislation's on their side, numbers are on their side, because often, as we know, where there's smoke, there's fire. And, it's not just one person who's been harassed by this individual. We see it in Harvey Weinstein. We see it in all of the cases in the courts or on the media right now. It's a pattern of behavior, and it's been, perpetrated against many, many people over time. So you get one person coming forward and you just don't know what's going to happen. So I would recommend that you take proactive action. And if there's any outstanding, questions or reports that perhaps you haven't looked into to date, that you go back and start to manage those and find out what's happening. It's better for you to control it than to have it control it and deal with it and treat people fairly if they've been harassed, than to have this come out. The other thing is protecting the dignity of the person who's been victimized. It is a terrible thing, and I've talked about it, that happens to individuals when they've been harassed in the workplace. It's violence against the soul. And I think all of us are in the business and the life of helping other people, and we don't want this to happen to those in our charity family, as well as for those people that or causes or that we are seeking to change in the world. So we can start this right at home by protecting the dignity and safety of people in our organizations. Putting in place in performance management markers for respectful behavior, certainly giving the Bill 132 training or other communication skills training. Sometimes people just don't know how to communicate and they don't understand the impact of their behavior and communication style. So, it's often fairly straightforward to say, okay, when you talk like that to people, they feel humiliated, they feel put down, they feel all these other things. You may not intend it, you may not realize it, but I'm telling you this now, and it's really important that you change your style. We can't have this kind of communication in our organization. Giving feedback like that's quite direct. And again, focus on behavior. What is it the person does? They yell, they slam books down, they micromanage. What is it that they're doing? Focus on the behavior, focus on the actions, and hold people accountable and build it into your performance management. It makes it much more of an integrated process. And then ultimately, there need to be consequences if people don't change. If you can't have these behaviors flourishing in organizations. So, it needs to be understood that if someone does this and it is found that they have continued to do that and they aren't willing to change, or people are being severely negatively impacted, they need to be let go. That's the furthest along consequence. I always like to think about rehabilitation, and that all of us, with the exception, of course, of psychopaths and fairly disturbed people, have the ability to change, and we can help them change. So let's always keep that in mind as well, but not at the expense of some of the people who are victimized. Another thing I'd like to touch on is return to work after mental injury, whether it's based on harassment and bullying or anything else. When a person's been bullied and harassed by someone in the workplace, you can't have them work with them again unless that person is completely rehabilitated and that's been a healed relationship. And the serious cases I've dealt with, it's actually impossible to repair the damage done by that. People are, in our practice, we're actually diagnosing a lot of post-traumatic stress disorder, PTSD. People get flashbacks, people get nightmares. They're actually terrified by the events that have happened by the perpetrators in the organization. So you need to think about your return to work plan, because you can't put people, you can't expose them again to the people who perpetrated harassment or bullying or emotional violence against employees. So it opens up that piece as well. How are you going to handle that and protect those workers coming back? Don't just post or distribute policies and codes of conduct. They are great to have, and be sure you have them, because when you're conducting an investigation, you want to be able to go back and say, look, that our code of conduct is X, Y, and Z. So you've been made aware of that. Our policies. You've had the training on Bill 132. So you're able to refer back to that with the individual that you're investigating, as well as when you and others in the organization are coming to consensus around, your decision with regard to the investigation. You can bring in speakers for lunch and learns about mental health and psychological health and safety. I know one organization that had, like, every summer they did a barbecue, and it was just a heart barbecue, and they just, shared information about harassment-free workplace and made it kind of a fun team-building event for everyone. And they did some really cute, innovative things. Provide resources to employees and managers, so other resources. And the HEART program that Dr. Bott and I developed was really developed to create a psychologically safe and mentally healthy workplace. And that program is in over 1,000 organizations in Canada and the United States. And it allows for a team who can respond to either questions about harassment or to make a report to that individual who's been trained. So it makes it easier and more comfortable for people to come forward and know that their complaint is taken seriously and that there's a compassionate but also a legislatively and legally and psychologically sound response within the organization. So you need to make sure that you're covered. It's mandatory that you train your employees and managers. We have an online Bill 132 training program. And the investigation program, which is a manual with downloadable forms, investigation procedures, all of that. And that's we're giving a 10% discount on that to all people who have registered for the webinar today as a courtesy and as in partnership with Charity Village. You need to train your harassment response person or team. Again, I said I do that, and we have other people who do that as well. Or organizational harassment advisory investigation services for external investigations. You can, use our online courses for manager training, communication, interpersonal skills training. We've developed, our psychologist developed a rehab program for bullies. Now, that's not for the extremes, like a Harvey Weinstein, a Jian Ghomeshi, people like that. You just need to keep everybody safe from them. But for people who genuinely don't know and understand and are willing to learn and change, one organization said that they went from being ready to fire the bully in their organization to that person being voted Employee of the Year. So it was really life-changing all the way around. And we have victim support, self-help program, and counseling for people who have been traumatized and deeply impacted by the effects of harassment and bullying in the workplace. So now I'm going to take questions from those of you who have been listening. There's also, if you wanted to reach out to us, I've got our number there at BizLife, our email, or if you want to contact Charity Village directly, feel free, help@charityvillage.com. So let me, Marina, I guess if you've got some questions that have come in, I'd be happy to answer them.
Thanks, Donna. Yes, we do have lots of questions coming in, and you can keep popping your questions in the question box. If you have questions for Donna, we're going to get to as many as we can today. So Donna, let's get started with how would an organization know when to bring in an outside investigator?
Well, I would say that, as I mentioned a little earlier, if you do not have the proper protocols in place yourself, and or if you feel that the investigation will be influenced by someone in power or by some entity, I don't know what that would be, but if you don't feel that it can be done independently and fairly, then you need to bring in someone from the outside. Because as I stated in that most recent legal case, the trial judge said that because the individual internally mishandled the investigation, incredible damages, and rightly so, were awarded to the person who complained.
Great. And moving on. So in the harassment program and policies, should there be a recommendation that the person first try to work things out with the person they believe is harassing them?
That is a common misunderstanding and myth and not helpful advice. Because, if there's a problem between two individuals, of course, you would work them out. But if you feel you're being harassed, if you feel that your voice won't be heard fairly, if you feel there are being negative repercussions to you, if this person has power or influence, it is absolutely not advised. And that's why the legislation says there needs to be a safe third party within the organization that individuals can go to feel safe reporting and who will conduct a fair investigation. So no.
Wonderful. And on that similar topic, we had a question come in. In the past, employers may have had both parties in the room together to quote unquote reconcile. Is this still a best practice, or could that be a form of continued harassment actually?
Again, you look at the power and influence differentials for one thing. And I would say no, like how do you work something out with your harasser? It's not possible. Now I would say if after an investigation takes place, and one of the recommendations of that is that the individual who harassed get treatment or attend a program and makes significant changes, then if the victim is okay with that, then and if it's well managed, a mediation is well managed, and the person who was victimized feels safe, then that could be a possibility. But I've had so many cases where the individual was re-traumatized and literally shaking at the thought of even having to be in a room with the other individual. So I would caution very much against it, unless a lot of healing and positive actions on the part of the harasser had taken place.
Thanks, Donna. Now moving on to the investigations, how much detail should be put in the investigation follow-up? Is it sufficient to say, quote unquote, appropriate action has been taken in order to maintain confidentiality?
You need to define what you do. It needs to be pretty transparent. Like what in our program we say, this is how we will keep confidentiality. We will not send emails. We will not do this. We will, that just a number of protocols, but these are the cases in which we cannot keep confidentiality. So those need to be defined very carefully and clearly for the individual, for both individuals, the accused and the person who's complaining.
And with the follow-up, are you obligated to provide investigation follow-up to all participants, including possible witnesses of the harassment?
No. So you can, and that's a good point. The witnesses is a very good point. Like it's very helpful to have those witnesses in an investigation. No, it would be for the person who complained, and explain to them, this is the process we went through. Now, you would have told them at the beginning of the investigation, this is the process we are going through. Come back around, this is the process we went through, and here's the conclusion we came to. And then you do that as well with the person who was accused.
And how does this legislation affect people that are served by the charity or volunteers? And I'm thinking the person asking the question is probably meaning harassment coming from those people to an employee.
So like a volunteer might be harassing an employee, that's what you're thinking, Melina?
Yes, or perhaps a client.
Right, so it's the or a client, yeah. So it is the obligation of the employer to keep that employee safe from harassment and sexual harassment. So that's kind of the beginning and end of it. You have to keep them safe in their workplace. And a workplace can be quite extensive. It can be a mobile workplace. It can be like a vehicle. It can be on a train. It can be on a plane. It can be at a hotel if there's a conference somewhere. It can be at a fundraising event. Wherever that employee is doing work for the employer, there is an obligation of the employer to keep that employee safe from harassment, from mental injury. Like there's more and more expectation for safety from mental injury. So again, that's why I recommend that you train your volunteers so that they understand this and that the commitment is by the organization or the employer to the employee.
And what if it was the opposite? What if, it was a client or a volunteer putting in a complaint about a staff member? Right.
So you still have you have an obligation because you've had a complaint come forward. So wherever there's a complaint of harassment, you have to investigate it. And, it may turn out to be something quite minor and it was a misunderstanding. You still have to investigate it. And you still have to, determine what actions, if any, you're going to take. So absolutely, that's a serious complaint against a worker or an employee or staff person in your organization.
Okay.
So you have to investigate, yeah.
Yeah, and now what if the complaint is actually filed by a third party, so not the harasser or the victim? Would you still start an investigation right away, or would you consult the parties involved first?
Well, part of the investigation is consulting the parties. So you would start obviously with the third party, who maybe they observe something. I'm guessing that's what you're thinking. They observe someone, and so you would have to get a report from that person. It's always, if you get a report, you have to investigate. So, you fill out the forms. We've got forms that you complete, getting details about the information and the incident and that kind of thing. And then you would talk to each individual separately about that report.
Now, we had a question, because I know earlier you mentioned the case where the person was being overworked, basically, as a form of harassment. Is there any kind of gauge or metric on that? The person asking the question kind of mentioned, and I'm sure a lot of folks on the call can recognize this, that in today's economic times, that's becoming more of an issue.
I know. Yeah. So the individual that I'm referring to had said that it was becoming a lot for them. And the employer essentially said, that's too bad. You're really good at what you do, so take it on. So I think there is, both sides have to speak about this. So I would say, if you're feeling that it is just too much, you're going to crash and burn. We all have limits. There's just so much that all of us can do, regardless of how well-intentioned or hardworking we are. So I think you need to be aware of your own limits, physically, emotionally, mentally, and to certainly talk to someone in the organization about the amount of work, and if something isn't done about that, to take it to HR. But you absolutely can't keep functioning like that if it's, you're working every weekend, every night, every holiday. This was the case, and trying to perform. And I have a lot of people who work in not-for-profits, and that is a big issue there. You're right, because you're very dedicated people, extraordinarily dedicated, and you can push yourself too far too. So I think really check in with yourself, and if it's too much, it's too much. Mm-hmm. And the National Standard for Psychological Health and Safety, it's called the Standard, is another big movement that's taking place in organizations. And one of the contributing factors is work overload. So that's now being recognized as a serious indicator of mental health problems in the workplace. So that's a good question. Monitor yourself and speak to people about it.
Good, thank you, Donna. Now, we've had a number of questions come in about how to handle complaints or for folks that are needing to make a complaint. And the harasser, as you mentioned, is in the leadership capacity. So maybe the person's manager that they need to report to, may even be the HR person, or could be involved in the investigation team. Do you have suggestions for that?
Well, they have to know that there's a safe person to report to, and their organization is obligated under Bill 132 to provide that safe person. It's part of the legislation. So, if you go to HR, HR is fantastic. The HR people I work with in not-for-profits are absolutely fantastic. But sometimes you'll have a case. I had a case of a woman who said, I can't go to HR because of the HR person who's harassing me. So there has to be that safe person. So I guess you would go to HR in this case and say, I'm not comfortable coming forward, but I need to know who is the safe person in our organization that's been designated to report to.
And if an organization doesn't have an outside person and isn't really willing to, to bring someone in, or can't due to lack of funds or something like that, what's the recourse for the individual person? Is there an outside body that they can go to?
Well, yes, they would go to the Ministry of Labor and report it, because the organization simply has to have these in place. There isn't any way around it. They have to have these things in place now.
Good, and that's why this is important.
Ministry of Labor would be who to contact.
Excellent. And we'll just finish off today with one last question. How often do you need to have your staff and volunteers trained? Is it once a year, or more often, less often?
Well, we recommend that everybody be trained, and then that as new people come on, that they're trained when they come on. And annually is really, that's what a lot of lawyers are recommending right now, that people are retrained annually on this, so that at least you're educating people on a regular basis.
Great. So I think we'll finish off there. I want to thank you again, Donna. This has been an excellent and much needed presentation. With, as you mentioned.
And thanks to everyone who attended for taking the time to attend.
Absolutely. Before we sign off today, I do want to remind everyone we'll follow up with you by email with the webinar recording. Watch for that tomorrow morning. We'll also include a link to a short survey. If you can take a moment to fill that out, that helps us for future webinar planning. You'll have an opportunity there to let us know if there's other topics you'd like to see covered. And we've also just announced the first of our 2018 webinars, so we will include a link for more information about those in the email that you get tomorrow. So do check those out as well. We've got a leadership and executive series happening early next year that I think you'll probably find interesting. So with that, I'd like to thank you again for joining us today. Thanks, Donna, and I hope you all have a wonderful rest of your day.